This is chapter 5 of We the People. So, equality through the law, equal rights, also referred to as civil rights, are terms that refer to the right of every person to equal protection under the laws and equal access to society's opportunities and public facilities. The 14th Amendment, Equal Protection. So the Equal Protection Clause forbids states from denying equal protection to citizens. But there was segregation in the schools, as we all know. But Brown versus the Board of Education of Topeka, Kansas, of 1954, banned the forced segregation of schools. There was little change to segregation seen up to 15 years later, and the Supreme Court encouraged busing as a solution to segregation, which was a highly controversial approach, and it showed mixed results. And it was ended in 2007, and then what we call white flight, when white people leave the inner cities and move to the suburbs. Because of these two things, schools have become less racially diverse. And the busing was overturned by the Supreme Court because it ruled that busing violated the students' right to equal protection. So students from different school districts would be bused into another school district to try to make one school or the other more diverse. But the Supreme Court ruled that it violated the students' rights to equal protection. And segregation in school was a violation of the right to equal protection. And that's why Brown versus the Board of Education of Topeka, Kansas, was able to ban forced segregation, because segregation was against the Equal Protection Clause. But then, interestingly, busing, which was an attempt to make schools more diverse and less segregated, was eventually ruled 50 years later to be also against the Equal Protection Clause. It's kind of an interesting turn of events there. There are judicial tests for equal protection. The reasonable basis test is that inequalities are allowed when they are, quote, reasonably related to a legitimate government interest. The strict scrutiny test presumes that the law is unconstitutional unless the government can provide a compelling basis for it. One example of strict scrutiny is suspect classifications. Suspect classifications says that race and national origins used to classify people are assumed to have discrimination as their purpose, and then they would be against the Equal Protection Clause. So remember strict scrutiny and remember suspect classifications. So the suspect classifications suggest that laws that classify people differently on the basis of their race or ethnicity are presumed to have discrimination as their purpose. Gender classifications have been placed in an intermediate or almost suspect category. For example, different treatment is allowed based on gender if it is substantially related to the achievement of important governmental objectives. This is a good slide to look at. It clearly shows you what strict scrutiny, intermediate scrutiny, and reasonable basis tests are, what you apply them to, and how they're used. The Civil Rights Act of 1964 required that all persons cannot be discriminated against when seeking employment, nor when they use public accommodations. So all persons are entitled to equal access to public accommodations. and medium-sized and large firms cannot discriminate on the basis of race, color, religion, sex, or national origin in the hiring, promotion, and wages of employees. Some forms of discrimination, though, are still lawful. For example, church-related schools can take religion into account when hiring their own teachers. The Black Civil Rights Movement. The motivation behind the Civil Rights Act of 1964 was the Black Civil Rights Movement. For example, we saw the Montgomery bus boycott, which was led by Dr. Martin Luther King Jr. There was also the March on Washington for Jobs and Freedom, and that was conducted by African Americans seeking equality of rights. So, March on Washington was conducted by African Americans seeking equality of rights. Resistance to the Civil Rights Act was widespread, but overt discrimination gradually ceased. Women's rights. The first large and well-organized promotion of women's rights was 1848 in Seneca Falls, New York. The 15th Amendment extended the right to vote to men of color, but not women. And the 19th Amendment, finally, the right to vote extended to women. So the Equal Rights Amendment was introduced in 1923. It was passed 50 years later, but it failed state ratification. And a big supporter of the Equal Rights Amendment was and is Ruth Bader Ginsburg. And I'm sure most of you know her. She's a Supreme Court justice who's become quite famous and popular lately. You should also note that currently women make 80% on the dollar compared to what a man makes doing the same jobs, 80 cents on the dollar. And in the news recently was the women's U.S. soccer team, and they won the World Championship, or they won the World Cup. I'm not quite sure what it was, but they did a great job. They win all the time, and they're paid significantly less than the U.S. men's team, who that team wins a lot less and doesn't bring in nearly the amount of people to their games, but they're still paid a lot more than the women are. So that's just an interesting case study. You can look that up if you didn't hear a lot about it. Hispanic Americans and the farm workers strikes. The farm workers movement was led by Cesar Chavez. Strikes in the 1960s and 1970s for migrant workers' rights. Workers' actions forced California to pass a law giving migrant workers the right to bargain collectively. The strikes were most successful in California, so if you'll remember that, the movement for migrant workers' rights was most successful in California, and it had limited success in other states, such as Texas. Native Americans and their long-delayed rights. Native American population decreased from at least $5 million when, 5 million people when white settlers first arrived to only about 250,000 by 1900. They were not granted citizenship until 1924. The Indian Bill of Rights, passed in 1968, provided for constitutional guarantees for Native Americans on reservations, and protests led to greater control over their own affairs. Asian Americans and immigration. Chinese and Japanese laborers were brought to the western states as laborers in mines and railroads in the late 1800s. So remember that Asian laborers coming to the United States worked in mines and railroads. In 1892, Congress suspended Asian immigration. That suspension was lifted in 1965. The Voting Rights Act of 1965. So let's talk about what happened before that. So, before 1965, the 15th Amendment in 1870 granted blacks the right to vote. And blacks were disenfranchised by whites only primaries, rigged literacy tests, and poll taxes. In the mid 1940s, the Supreme Court declared that whites only primary elections were unconstitutional. The 24th Amendment in 1964 outlawed the poll tax, and 2 years later, the Supreme Court banned literacy tests. So the Voting Rights Act of 1965 allowed federal agents to oversee voter registration. So it prohibited discrimination in voting and voter registration. So the Voting Rights Act of 1965 prohibited discrimination in voting and voter registration. States were prevented from creating election districts that deliberately diluted the minority vote. And even though states have been prevented from doing so, there are still cases that could be legitimately brought up today where this has been happening. You might want to look into the trouble that the state of North Carolina got in the midterm elections of 2018. I can't remember if it specifically included district creation, but there were definitely some voting injustices committed. North Carolina, 2018. So the Voting Rights Act of 1965 was actually significantly weakened in 2013 during the Shelby County versus Holder decision, and Eric Holder was the I can't think of the Attorney General of the United States. Sorry, Eric Holder was the Attorney General of the U.S. in 2013, and that case invalidated portions of the law. So under that case, the Supreme Court argued that Congress had set rules to protect voting rights that were no longer relevant. So, interesting. The Civil Rights Act of 1968. In 1968, Congress passed legislation addressing discrimination in housing. It prohibited redlining, which was the refusal of mortgages for homes in certain neighborhoods, primarily those with large black populations. However, the strong patterns of housing segregation are still apparent, and African Americans and Hispanics still have more difficulty obtaining mortgages than whites with comparable income levels. So remember that the Civil Rights Act of 1968 addressed discrimination in housing. Affirmative action is deliberate efforts to provide full and equal opportunities in employment, education, and other areas for disadvantaged groups. For organizations receiving federal funding or contracts. And there were cases that were brought up that challenged affirmative action, such as the University of California Regents v. Bakke in 1978. So remember that case was over affirmative action. So the Bakke case dealt with affirmative action, but actually the need for affirmative action was upheld under that case. There are different types of discrimination. De jure discrimination is discrimination based on the law. De facto discrimination is the condition whereby historically disadvantaged groups have fewer opportunities and benefits because of prejudice and economic circumstance. There is a new concept of equality of result, and affirmative action sought to alleviate de facto discrimination. Progress has been made toward a more equal America, but civil rights problems involve deeply rooted conditions, habits, and prejudices. America's traditionally disadvantaged groups are still substantially unequal, in their daily lives. African Americans, there is continuing high disparity in income. There are discrepancies in convictions and sentencing. There is a higher incarceration rates than the general population. But they have made substantial progress in elective office. There are more than 500 black mayors. There are 40 black members of Congress. And the 44th President of the United States, obviously, was Barack Obama. The women face job-related issues such as lack of job equality, family leave, and gender pay equality are continuing problems. And there's also a concept called the feminization of poverty, which is when most single-parent families are headed by women, and about 1 in 3 of those families live below the poverty line. Electoral and political successes, and there have been electoral and political successes in the Supreme Court, presidential politics, and congressional seats. You might want to remember that President Reagan actually appointed the first female Supreme Court justice, and that was Sandra Day O'Connor. So remember that. Sandra Day O'Connor, the first Supreme Court justice, was appointed by President Ronald Reagan. Full-blooded Native Americans, including Alaska Natives, currently number more than 2 million. Half live on or near federal reservations. Federal authority is defined by treaty terms, and state governments have no direct authority. The current policy goals of the federal government include retention of native cultures and self-government and economic self-sufficiency. Tribal state conflicts persist over gaming, however. Hispanic Americans are one of the oldest ethnic groups in the nation. They colonized Florida, New Mexico, California, and Arizona. They're the fastest growing minority and largest minority group. Hispanic immigration issues persist, however. More than 4,000 Hispanic Americans hold public office. They are in Congress, the Supreme Court, presidential politics. About half of all Hispanic Americans are registered to vote, and as a group, they are a political force in states like Texas, California, and Florida. Asian Americans now number about 12 million. Most live on the West Coast, particularly in California. They are upwardly mobile. They're family-based, self-reliant, with an emphasis on education. They have the highest rate of two-parent families and the highest rate of median family income. They are educated and driven, yet underrepresented politically and in managerial jobs. The Civil Rights Act of 1964 classified only women and minorities as legally protected groups. Other disadvantaged groups have gained protection through other legislation. For example, the Age Discrimination and Employment Act of 1967 and the Age Discrimination Act of 1975. Disabled Americans are also provided for through the Education for All Handicapped Children Act of 1975 and the Americans with Disabilities Act of 1990. Other disadvantaged groups are the LGBT community. They were formerly barred from military service and had no employment protections or rights. Such prohibitions no longer exist, and greater legal protections in some jurisdictions for the transgendered. The U.S. has seen a rapid swing in public opinion toward acceptance of same-sex marriage in the last 2 decades, particularly among younger adults. Massachusetts was the first state to permit same-sex marriage in 2004, and the Supreme Court case Obergefell v. Hodges in 2015 expanded the right to same-sex marriage to all Americans. One thing to remember is that if you're a younger American, you're more likely to not have a problem with same-sex marriage than older Americans. Americans' high ideals often clash with its reality. It is still necessary to combat America's curse, which is discrimination. Abraham Lincoln said that the United States is a nation, quote, dedicated to the proposition that all men are created equal. Thank you very much. That was chapter 4.